The marble pillars of the Supreme Court stood tall and graceful as soft morning light poured through the grand windows. Inside, the nation's highest court gathered to hear Wilson v. Educational Opportunity Foundation, a major case dealing with equal access to education across communities. Most legal analysts expected a serious but ordinary day focused on technical debates over funding formulas and jurisdiction. Chief Justice John Roberts led the session with his usual calm confidence. At 70, he had presided over thousands of arguments, earning broad respect for his sharp legal insight and fair approach. Even from those who often disagreed with his rulings, among those presenting was Representative Jasmine Crockett, a former civil rights lawyer who had submitted an amicus brief and been granted time to speak. Though well regarded in legal circles, few expected her appearance to stand out among the elite advocates that morning. What followed, however, left the courtroom in stillness. As Crockett finished her powerful argument on educational fairness and constitutional principles, Chief Justice Roberts leaned forward. Rather than move directly to questions, he paused and spoke, something rarely done in the Supreme Court's formal setting. "Representative Crockett," he said clearly, his voice steady but sincere. "Before we proceed, I want to acknowledge something. In all my years on this court, I've seldom encountered legal reasoning that ties together constitutional principles, precedent, and real-world impact so precisely. Your advocacy today represents legal excellence at its finest." The emotion in his tone was unmistakable. This wasn't routine courtesy, but genuine respect. In that moment, everyone in the chamber, justices, lawyers, reporters, and visitors, felt the weight of what had just happened. It was a powerful exchange between the nation's top judicial figure and an advocate, whose brilliance transcended political lines. Before we continue this remarkable story, please take a moment to like this video and subscribe to our channel for more inspiring stories of legal excellence, integrity, and leadership beyond politics. To understand why this exchange between Chief Justice Roberts and Congresswoman Crockett struck such a chord, it helps to look at their individual journeys. Roberts had long been a model of disciplined scholarship and steady judgment. After graduating from Harvard Law School, where he served as managing editor of the Harvard Law Review, he clerked for then-Justice William Rehnquist. His early years included work at the Department of Justice and in private practice, where he argued 39 Supreme Court cases before his appointment to the bench. Named Chief Justice in 2005, Roberts earned a reputation for careful, balanced jurisprudence that respected tradition while remaining open to evolving interpretations. Though often conservative in outlook, he occasionally surprised observers with decisions that crossed ideological lines when he felt the Constitution required it. Legal scholars often note Roberts' deep devotion to the court's integrity above partisanship. A former clerk once said, "The chief believes profoundly that the court must stand as an impartial guardian of constitutional principles, not a political instrument." That belief defines everything he does. Known for his demanding yet fair questioning during oral arguments, Roberts' recognition of truly exceptional advocacy was rare and therefore deeply meaningful. Jasmine Crockett, meanwhile, had carved a different but equally compelling path. After finishing law school, she built her reputation representing clients from underserved communities in civil rights and education cases. Instead of pursuing corporate law, she chose to stand with those most affected by inequality. This hands-on experience gave her unique insight into how legal rulings shape real lives. Her approach to constitutional law wasn't just theoretical. It came from witnessing firsthand the struggles and hopes of the people she served. Over time, Crockett became known for landmark victories in civil rights litigation before running for Congress, where her background set her apart. Unlike many legislators who leave courtroom advocacy behind, she continued to bring deep legal analysis into her policymaking. The Wilson case, which placed her before Chief Justice Roberts, tackled one of America's toughest issues, whether funding gaps between school districts violated the Equal Protection Clause. The case touched on local control, federal responsibility, and the core promise of equality, issues that had split courts and Lawmakers for generations, if you've ever witnessed a moment where professional respect rose above political division, share your thoughts in the comments below. These rare moments remind us that true expertise and integrity still unite people across divides. On that morning, the Supreme Court chamber, filled with justices, clerks, journalists, and an eager public, became the setting for a moment that would soon spark national conversations about what respect, excellence, and principle look like at the highest level of law. The Supreme Court session opened with its usual sense of ceremony. The marshal's formal announcement echoed through the chamber as the 9 justices took their seats, handling procedural matters swiftly before turning to the day's main case. The first lawyer for the petitioners argued capably about local control and traditional funding systems, fielding sharp questions from justices across the political spectrum. Then came Representative Jasmine Crockett's turn, and from her very first words, seasoned observers could tell something was different, unlike many advocates, who start with sweeping theories or political overtones. Crockett began by stating the core constitutional question clearly and directly. "Mr. Chief Justice, and may it please the Court," she began with calm precision. "This case presents a fundamental question about how we interpret equal protection guarantees. When access to quality education, a foundation of meaningful citizenship, varies drastically based on local resources and tax bases." From that powerful opening, Crockett built her argument methodically, layer by layer, weaving together multiple strands of reasoning that reflected both mastery of doctrine and respect for precedent. She first traced the evolution of equal protection law, highlighting major Supreme Court rulings that shaped the court's understanding over time. Unlike many advocates who only cite favorable cases, Crockett directly engaged with decisions that might appear to weaken her position, and then carefully explained why they did not, in San Antonio v. Rodriguez. This court held that education is not an explicitly recognized fundamental right, she noted, referencing a precedent often cited against her side. However, in Plyler v. Doe, the court acknowledged education's unique role in sustaining civic life and preserving the social fabric of our nation. This willingness to address difficult precedent head-on drew visible interest from several justices, some leaning forward. The Supreme Court's subtle but unmistakable sign of engagement. Crockett then moved to her second main line of reasoning, exploring how the court's equal protection analysis had evolved from a narrow view of formal equality to a richer understanding that included substantive fairness. She supported this with exact quotations from opinions written by justices across ideological lines, demonstrating that her argument rested not on partisanship but on decades of constitutional development. Justice Elena Kagan broke the silence with the first probing question. "Counselor," she asked, "if we accept your framework for examining these disparities, what limiting principle would prevent similar claims about other public services funded locally?" It was a classic question that could derail many arguments, but Crockett responded with calm clarity. "Justice Kagan," she replied, "the limiting principle emerges from this court's consistent recognition that education occupies a unique place among public services because it enables citizens to exercise other constitutional rights meaningfully." She then outlined a 3-part test based on existing precedent, showing how courts could distinguish education cases from other funding disputes while respecting separation of powers. Next, Justice Samuel Alito raised a question from a different angle. "Your argument seems to require substantial judicial oversight of local education funding. How does that square with our traditions of federalism and local control?" Crockett's answer showed her depth of understanding and refusal to fall into ideological traps. "Justice Alito," she said, "federalism protects both state authority and fundamental national rights. The framework I propose maintains local control over most educational decisions while ensuring that extreme disparities, which violate equal protection guarantees, remain subject to federal judicial review." She then cited examples of states where local autonomy and constitutional equity coexist, showing that her argument strengthened, rather than weakened, federalism principles. Even skeptical justices appeared impressed by her measured and substantive reply. As her argument unfolded, Crockett introduced her third major point: empirical evidence linking educational resources to real-world outcomes. Unlike advocates who rely on rhetoric, she cited specific research studies with clear methodology, anticipating and addressing possible objections. Empirical data confirms what this court recognized in Brown v. Board of Education, she said. Education must be made available to all on equal terms if equal protection is to have real meaning rather than symbolic form. Modern longitudinal studies demonstrate that persistent funding disparities create exactly the type of arbitrary disadvantages the 14th Amendment was meant to prevent. Chief Justice Roberts, who had listened intently, finally asked what many considered the most difficult question. "Representative Crockett," he said, "your argument asks us to make comparative judgments about educational adequacy. Doesn't that risk drawing the judiciary into policy decisions that should belong to legislatures?" The room grew especially still. This was a defining moment. Crockett's answer combined humility with firm constitutional reasoning. "Mr. Chief Justice," she began, "the framework one proposed fully respects the legislature's primary role in shaping education policy, while preserving this court's essential duty to enforce constitutional guarantees." Her response showed deep respect for judicial restraint, yet firmly reminded the court of its responsibility to protect fundamental rights. She continued her explanation with remarkable specificity, connecting every constitutional principle to both historical context and the lived reality of unequal opportunity, the very intersection that made her advocacy so compelling. Crockett explained that the test she proposed would not require the court to decide education policies or set funding levels. Instead, it would ask a narrower and more constitutional question: whether funding disparities become so extreme that they effectively deny some children the basic education necessary to exercise their other rights and participate fully as citizens. From there, she linked her reasoning to the court's own institutional traditions. "This approach," she said, "builds on the court's long-standing practice of defining constitutional floors without imposing policy ceilings, protecting legislative flexibility while upholding the Constitution's guarantees." Throughout her presentation, what truly set Representative Jasmine Crockett apart was her composure under pressure. She treated the justice's toughest questions not as threats, but as opportunities to deepen her argument. Each answer built naturally upon her framework, showing a balance of constitutional rigor and respect for the court's authority. As she neared the end of her oral argument, Crockett returned to first principles. The Constitution's promise of equal protection means that when states choose to provide education, as all 50 have, they cannot do so in a way that systematically advantages some children and disadvantages others simply because of where they live, she declared. This court has both the authority and the duty to enforce that principle, while leaving room for lawmakers to shape specific educational policies. Her final words captured both moral conviction and deep constitutional understanding. "The framework I've presented allows this court to uphold its role as guardian of equal protection, while preserving proper respect for legislative judgment. It aligns with the court's own precedents, honors federalism, and stays true to the Constitution's core promise, equality under the law." When she finished, a profound stillness filled the chamber, that rare kind of silence signaling extraordinary advocacy. Even seasoned attorneys waiting for their own cases had stopped reviewing notes, absorbed completely by what they had just witnessed. Then came the moment that would soon be discussed across the legal world. Instead of moving immediately to the next presenter, Chief Justice John Roberts leaned forward. His tone was steady but unusually personal. "Representative Crockett," he began, "before we move to questions, I want to acknowledge something. In my years on this court, I have rarely encountered legal reasoning that so clearly connects constitutional principles, precedent, and real-world impact. Your argument today represents advocacy at its finest. The courtroom went completely silent. Those familiar with Supreme Court proceedings knew how extraordinary this was. Chief Justices seldom interrupt to deliver direct praise, and Roberts, known for his measured temperament, did so only in the most exceptional circumstances. His words carried unmistakable sincerity. Your ability to anticipate and address institutional concerns while maintaining a coherent constitutional framework, Roberts continued, reflects the kind of rigorous thinking that strengthens this court's deliberations, regardless of where individual justices may ultimately stand. This wasn't polite formality. It was genuine professional admiration. The Chief Justice's comments recognized intellectual integrity, precision, and the rare quality of argumentation that elevates the entire legal system. Justice Sonia Sotomayor, often on the opposite end of Roberts's judicial philosophy, nodded in agreement, a subtle but powerful sign of shared respect. Though their ideologies differed, both recognized the brilliance of Crockett's reasoning, Roberts concluded with words that would echo beyond the courtroom. Advocacy of this caliber lifts the entire legal profession. It reminds us that the best legal argument is not about partisanship, but about a faithful, principled reading of the Constitution. The silence that followed was not one of surprise, but of reverence. Everyone in the chamber, justices, lawyers, and journalists alike, understood they had witnessed something rare and important. Even reporters, often focused on ideological battles, realized this exchange had transcended politics. After several seconds, Crockett responded with grace that matched the moment. "Thank you, Mr. Chief Justice," she said. "Having the chance to present these constitutional questions before this court is the highest privilege in our profession. I'm deeply honored by your words." The brief exchange captured something timeless about true legal excellence, that beyond politics and disagreement, principled reasoning and professional integrity still command universal respect. Justice Stephen Breyer, known for his practical approach to constitutional questions, then leaned forward to build upon Crockett's framework rather than challenge it. "Representative Crockett," he said thoughtfully, "based on your reasoning, how would you suggest the court define the standard for determining when educational disparities cross the constitutional threshold?" His question wasn't a critique but a continuation, clear evidence that Crockett's exceptional advocacy had shifted the entire tone of the discussion. The debate was no longer about whether her argument had merit, but how it might shape the future of constitutional law and education. The exchange between Chief Justice Roberts and Representative Jasmine Crockett marked a level of engagement usually reserved for the most compelling arguments, the kind that captures the attention of every justice regardless of prior leanings. Crockett's calm and precise response to Justice Stephen Breyer's question showed exactly why her advocacy had earned such respect. "Justice Breyer," she began, "I would define the standard by asking whether disparities effectively block children from receiving the foundational education necessary for exercising other constitutional rights and participating fully in civic life. This approach examines both resources and results, using a practical, not purely formal lens." She went on to outline clear, workable criteria that courts could apply without intruding into legislative policymaking. Her framework acknowledged real concerns about judicial overreach while offering a principled guide for enforcing the Constitution's guarantees, a careful balance that impressed observers across the spectrum. It was exactly the kind of nuanced analysis that earns professional respect, no matter one's political stance. As questioning continued, justices from every corner of the court, conservative, liberal, and moderate alike, engaged directly with Crockett's framework. Their questions didn't necessarily signal agreement but demonstrated intellectual respect for her reasoning. They tested her logic, explored the limits of her theory, and examined its real-world applications. This kind of substantive back and forth was a sign that the court was treating her argument seriously, on its merits, not its politics. Through it all, Crockett remained composed and analytical. She never grew defensive under tough questioning or triumphant when receiving supportive remarks. Each response showed discipline, respect, and depth, reinforcing the very qualities Roberts had praised. Her unwavering professionalism confirmed that this was more than a strong presentation. It was a model of legal advocacy at its finest. When her allotted time ended and the next attorney rose, something unusual occurred. Several justices, including some likely to disagree with her position, began jotting down notes, not just to prepare counterpoints, but to capture her analytical structure and phrasing. Even in the press section, journalists who had arrived, expecting another ideologically divided session, found themselves covering a moment that transcended those usual narratives. It was clear to everyone in the chamber that they had witnessed something rare, a display of professional excellence and mutual respect that reminded people why the Supreme Court remains one of the nation's most revered institutions. What neither Roberts nor Crockett could have foreseen was how rapidly this moment would spread beyond the courtroom. Within days, word of their exchange echoed across law schools, legal forums, and bar associations. What might have been a routine day of oral arguments had become a defining story about excellence in legal reasoning and the power of respect across ideological divides. When the official transcript and audio recording of the session were released, they circulated widely, far beyond typical legal circles. Professors from top law schools, regardless of their political leanings, shared the argument with students. It wasn't used to promote a particular legal view, but as an example of extraordinary advocacy and professional integrity. In my 30 years of teaching constitutional law, said one professor, I've rarely used oral arguments as direct teaching tools. But Crockett's presentation and Chief Justice Roberts's recognition of it offers something future lawyers must study. It's a reminder that great advocacy comes from clarity, preparation, and principle, not ideology. Major law firms also began incorporating the exchange into their professional development programs. A senior partner at a national firm explained, "What makes this so valuable isn't that Roberts and Crockett agreed. It's that both demonstrated what real legal excellence looks like. Anticipating counterarguments, engaging respectfully with precedent, and building logically consistent frameworks. Those are the hallmarks of great lawyering." The impact reached well beyond classrooms and firms. At judicial conferences, bar associations, and continuing education seminars across the country began referencing the Roberts Crockett exchange in discussions about excellence in advocacy. These conversations highlighted 3 lessons from Crockett's presentation: precision in defining constitutional questions, thoughtful engagement with challenging precedent, and deep respect for institutional roles while advancing principled arguments. For both Roberts and Crockett, the national attention was unexpected but meaningful. When asked weeks later at a judicial conference, Roberts offered a measured reflection. The court functions best when presented with the strongest possible reasoning from every side. Recognizing exceptional advocacy isn't about agreement. It's about appreciating analysis that helps the court fulfill its constitutional mission. Crockett echoed that sentiment in a speech to students at her alma mater. "What matters most," she said, "isn't that my argument was recognized. It's that our legal system still has room for real engagement across philosophies and perspectives. The law, at its best, is about ideas, not ideology." The broader impact of their exchange soon became clear. In a time when coverage of the Supreme Court often focuses on partisanship, this moment reminded the nation that law and politics are not the same. Beneath the surface of ideological battles lies a legal tradition built on reason, discipline, and respect for constitutional principle. Even commentators, who typically frame court decisions through political narratives, shifted their focus. One respected constitutional scholar summed it up best: "What makes the Roberts-Crockett exchange so significant isn't mere courtesy between 2 accomplished professionals. It's the living proof that even in polarized times, legal craft, intellectual honesty, and principled reasoning still unite the profession." It was a powerful reminder that at its best, the Supreme Court operates not as a political arena, but as a legal institution grounded in reasoning, fairness, and principle. It showed how genuine legal excellence can earn respect from every side, regardless of ideology, 6 months after the Wilson arguments. As the legal community eagerly awaited the court's ruling, law schools across the nation organized a coordinated series of programs, exploring what true excellence in legal reasoning looks like across divides. Judges, attorneys, and scholars from diverse judicial backgrounds gathered to discuss how Representative Jasmine Crockett's advocacy reflected the kind of thoughtful engagement that elevates the entire legal process. One federal judge summarized it best during one of these events. What Representative Crockett demonstrated wasn't advocacy designed only to please those who already agreed with her. It was advocacy that earned respect from those who didn't, because it took their concerns seriously and addressed them with substance. This focus on substantive engagement rather than persuasion revealed a deeper understanding of what advocacy truly means in a constitutional democracy. As one distinguished appellate attorney put it, the highest form of advocacy isn't about scoring rhetorical victories. It's about advancing understanding, helping courts and citizens alike grasp how constitutional principles apply in real life. True advocacy respects differing views while holding firmly to principle. Law clerks from that Supreme Court term later shared, with proper discretion, that Crockett's analytical framework had become a meaningful point of reference during internal discussions among the justices. Without disclosing private deliberations, several clerks noted that her reasoning was cited repeatedly across ideological lines, even by justices who ultimately disagreed with her conclusions. When the court finally issued its decision in Wilson v. Department of Education, observers noticed something unusual. As expected, the justices differed on specific interpretations of the Equal Protection Clause. Yet, parts of the opinion revealed shared analytical ground that reflected key elements of Crockett's framework. Chief Justice Roberts' majority opinion included a rare acknowledgement. While members of this court may reach different conclusions about specific applications of equal protection principles to educational funding, we recognize the exceptionally thoughtful framework presented during oral argument, which helped clarify the constitutional questions at stake. This kind of explicit citation, crediting an advocate's contribution to the court's reasoning, was extraordinary. It confirmed how deeply Crockett's legal analysis had influenced the court's understanding of the issues, transcending political and philosophical divides. In the months that followed, law schools across the country began integrating the Roberts-Crockett exchange into their curricula. Instead of focusing solely on winning strategies or persuasive flair, professors emphasized how true advocacy strengthens the judicial process itself through rigorous reasoning, respect for precedent, and engagement across perspectives. A year later, a consortium of top law schools announced the launch of the Excellence in Constitutional Advocacy program, a new initiative designed to train future lawyers in the very qualities Crockett had displayed: precision in reasoning, substantive engagement with complex precedent, and principled advocacy that earns respect across ideological lines. Invited to speak at the program's launch, Crockett used her remarks to refocus attention on the values that matter most in legal practice. Excellence in advocacy, she said, serves something far greater than any single case. Our constitutional system thrives when courts hear the strongest possible arguments from all sides. When advocates anticipate opposing concerns, address them honestly, and maintain analytical integrity, they help strengthen the foundations of our democracy. Chief Justice Roberts, while declining formal participation to preserve judicial neutrality, sent a message that echoed the same values. The quality of advocacy directly affects the quality of judicial decision-making. When advocates present rigorous, principled arguments that engage sincerely with differing views, they help the courts fulfill their constitutional purpose. The story of Roberts's recognition of Crockett's legal brilliance became more than a courtroom moment. It became a teaching example across the legal world. It showed that beneath the noise of political narratives, America's legal institutions still hold space for excellence, integrity, and principled reasoning. Their exchange stood as proof that substantive,